Welcome everyone to our final series, our final week of the Legal and Financial series. I have Angela Odinsky and Rose Ann with AARP, and we are so happy that you're here today. My name is Ariel Green. I am with Care Partners. I'm the Caregiver Support and Education Specialist, and we are here to support you as family caregivers and by providing education as well as support to you. So if you are in need of any additional resources, such as consultation, or want to learn more about our programs, such as our adult day centers, our gathering place, or any upcoming events, please feel free to email me. I will make sure you have our information in the chat, and then also we'll be sending that out once we send out the presentations and the recording. So I'm going to turn it over to you, Rose, to start us off, and she's going to kick it to Angela. So thank you all for being here.
Thank you.
Okay, again, good morning. Well, no, it's afternoon. Good afternoon, everyone. And I'm so excited and a little sad because this is our third in a three-part series on legal information that is most helpful, most needed for us. And as you overheard in my conversation, I've just been jotting down, and and there's just so much to learn. And so this has been a really terrific learning experience. And now I am Rose Childress, a volunteer with AARP. And AARP is a nonprofit, nonpartisan member organization that's dedicated to providing information and resources that are important to people that are over 50 and their families. Now, AARP's, our social mission is to empower people to choose how they live as they age. And that's what Angela is doing. That's what she's bringing to us. Okay, she's bringing that good educational information in regards to caregiving and planning before you need care. Okay, and most importantly, before you need care. And then it also gives us some things to think about if we are in the caregiving mode right now. And so now our founder, Dr. Ethel Percy Andrus, was an educator, and she believed that people could choose how they live as they age. Now, let's see. Now, our main focus is to promote independence, dignity, and purpose for older people, and to enhance the quality of life, and to encourage older people to serve and not be served. And that is my purpose here today as a volunteer. I am here as a service to you. And if you, no matter where you are, and I know that we have people from all over who are tuned in to this webinar. So if you want to find out more information about AARP, if you're interested in volunteering, no matter where you are, just go to www.aarp.org/near-you, and you'll find out about a lot of different activities that we like to have fun with a purpose, such as our cooking classes, our gardening classes. And then we also want to learn so that we can be prepared for anything in the many different phases in our life. And so on the website, you'll find videos on how to do certain things. You'll find written information. You can get booklets such as the Prepare to Care guide, which lists a number of things that you need, records that you should have available in the event that something happens. And just to me, it's like a way of organizing. And so, and we need to be organized, because we don't know at any time someone might have to pick up and take over for us, whether it's for short term or for long term. And then also, and I thought of this yesterday, we, at our age, we might be caring for older family members, or we might have a younger family member with say, for instance, autism or any of those things. And we've got to think about those things beforehand. So not just us personally, we've got to think about those ahead of us and those that are below us. And I'm sure Angela is going to talk to us about all those different topics. And it's my pleasure to give you Angela Odinsky.
Thank you so much, Rose. So welcome back, everybody. This is our third installment. The first day we talked about essential documents, things that every person should have, especially if you are over the age of 18. I think I harped on this a lot the last two sessions, but I'm going to say it again. The durable power of attorney is the single most important document you can have while you're alive. And in the past 2 weeks, since I've been doing these talks with you guys, I've had, I don't know, at least 3 more examples of situations where people come in and we can't do what needs to be done because either there is not a power of attorney in place, or the power of attorney that is in place doesn't do what doesn't give the powers to do what's necessary. And so we're having to scramble to sort of help these families and take care of things. So if you're a young one, if you are middle-aged, if you are, I don't care, have a durable power of attorney. It is so necessary. And so the first one's on essential documents, and that one to my mind is the number one essential document. The second one we did was about planning for your long-term care. What can you do ahead of time to make sure that you get to age the way that you want to age, to do the things that you need to do, put things in place so that your wishes are and your intentions are known and honored. Today, we're moving into something a little bit more hairy. We're talking about Medicaid qualification. So if we have done everything that we can do, but now we've just gotten to the point where we are not able to stay at home anymore, or we need round-the-clock skilled care and we don't quite know how to pay for that, or we have some long-term care insurance, but it's not quite enough. We have some income, but it's not quite enough. What do we do in those circumstances? And so today we're talking about Medicaid qualification. It is an incredibly complicated topic. I am simplifying it quite a bit, just so you kind of understand the basics of it. There's going to be a lot of questions. I'm going to answer some of your questions, and a lot of you are going to have your own questions, and it's going to be based on your circumstances. I am happy to answer questions that are of general knowledge for everyone. I am not going to be able to answer questions that are specifically related to your circumstances as we go forward. So I'm going to go ahead and share my screen. And I believe y'all should see the Law Office of Angela Odinsky slide.
Yes.
Ready to go. So we will get this started. So today's topic is really about crisis planning, right? So we are in a crisis. Usually when this happens, it's because we have an unexpected, unplanned need for long-term care. As an everyday scenario, your loved one is going along just fine, living at home on their own. They slip and fall, they break a hip, they break a leg, they break something, they break their wrist, they end up in the hospital. Bones slowly heal much slower, right? So they're in the hospital for a few days, and then they have to go into rehab to build that strength up. And so then we end up in rehab for a few days or a couple of weeks. And then all of a sudden, everyone realizes, wait a minute, the rehab stint's about over. We can't be in rehabilitation anymore, but our loved one is not ready to go home. Like, they can't be home by themselves. They can't take care of themselves on their own. What are we going to do? Right. So this is the crisis situation that usually comes up to me. It comes to my office when they hit the rehabilitation center. We also have unexpected or unplanned need for personal care in several areas, like that example where you broke a wrist, right? Being able to get up and down without being able to use one hand to steady yourself can be debilitating. And you require assistance to pay for the unexpected care. So again, we're going to talk about long-term care needs, what we're talking about: bathing, dressing, eating, toileting, caring for pets, shopping, housework, all of those things we talked about last week in terms of these activities of daily living and instrumental activities of daily living. These are sort of where we focus when we're talking about somebody who has a need for long-term care for personal needs. And again, sometimes private caretakers are enough. So you have home healthcare businesses that can offer a variety of services. Companion care or custodial care is a big one. So if you have a loved one with dementia or Alzheimer's or something where they are generally able to move around and do things, but they need someone to help them eat, remind them to eat, make their meals, help just kind of making sure that they don't leave the house and wander away. All of that is considered custodial care. So it's not considered skilled care or need for skilled care, but it's custodial. And so there are home care offices or home businesses that offer that kind of care. You want to choose only what's needed so as not to break the bank. So we often kind of cobble together family, friends, some home health caregivers when we can. Anytime you can hire somebody, it means you're giving unpaid family caregivers a much needed break. And it's always better to get help 10% of the time, for independence 90% of the time if possible. And it's definitely helpful to look at the housing modification. So if we're coming home from that rehabilitation stint, are there some easy housing modifications we can do to make sure our loved one can be safe in their home? Okay, so now let's get to the nitty-gritty. Who pays for what and how? What does Medicare pay for? There is an enormous number of people in our population who thinks that Medicare pays for long-term care. It does not. Medicare does not pay for long-term care services. Medicare pays for specific health and medical needs for acute conditions, but it does not pay for your general overall long-term care. So it'll pay for short stays in rehabilitation if the following criteria are met. So there has to have been a recent prior hospital stay of at least 3 days, and you have to have been admitted, not under observation. So it's really important that if you are advocating for a family member, that you know what their status is in the hospital, because a person can be in a room and still be under observation as opposed to actually having been admitted. And if you're under observation, that doesn't count towards that 3-day time period, right? So we need to be very aware of these terms and how they're used. So they have to have been admitted into the hospital for at least 3 days. And that 3-day time period starts midnight to midnight. So it's kind of a convoluted calculation. And then admitted to a Medicare certified nursing facility within 30 days of the prior hospital stay. There has to be a need for skilled care, such as skilled nursing services, physical therapy, or other types of therapy. So if you meet those criteria, then Medicare will pay for a certain number of days in rehabilitation. Medicare benefits generally it's health insurance, right? Your health insurance doesn't cover long-term care. Blue Cross Blue Shield doesn't cover long-term care, neither does Medicare. It doesn't cover personal needs, such as cooking, cleaning, shopping, those sort of instrumental activities of daily living we were talking about, pet care, things like that. It doesn't cover those. And it does not cover long-term skilled nursing. So what does it cover, right? So we said if you have that 3-day hospital stay, it can cover some cost for 100 days. So up to day 20 in the rehabilitation, Medicare covers 100%. On day 21 to day 100, the patient is responsible for a co-insurance of $200 per day. Now, some supplements might cover that. So if you have a Medicare supplement that covers additional expenses, then it could potentially cover up to day 100. Now, just because Medicare is going to cover those days or might cover those days, it does not necessarily mean that the rehabilitation facility won't try to discharge early. That is a whole different conversation, but just understand that though Medicare will cover it, it does not necessarily mean that your loved one can stay in a rehabilitation facility for that amount of time. It will depend on a lot of different factors. Anything beyond day 100 is fully the patient's responsibility 100%. So you can be in a rehabilitation facility until day 100, and then after that, everything is whatever their daily rate is. And that is going to be the patient's responsibility. Because that's when we kind of get into the long-term aspect of it. So then what is Medicaid? I have no idea why somebody outside of my pay grade decided to name these programs so similarly, but they are not similar. They are not the same thing. Medicare and Medicaid are not connected in any way at all whatsoever. But they're called very similar names, and so a lot of people get very confused about what they're talking about. And I know attorneys who can't tell the difference between Medicare and Medicaid because if they don't work in this area. It's very common to get these confused. Just keep in mind that Medicare is your health insurance, and Medicaid is a benefit program that can cover costs that are not covered by health insurance, okay? Or if you don't have health insurance. So it's a federal and state benefit program to address the cost of healthcare for low-income families. Texas has over 100 different Medicaid programs. So when someone comes into my office and they say, oh, well, my neighbor has Medicaid and they didn't have to do all this stuff that you've told me I've had to do. Okay, they might have a different Medicaid program than you need, because all the different Medicaid programs have different criteria and they offer different kinds of benefits. So just simply knowing someone who's on Medicaid and knowing what they had to go through to get it does not necessarily mean that that's going to have any relationship at all whatsoever to what you're going to have to do in order to qualify. They're all different and they have different criteria. They pay for different things. They have different qualifications. So it's important to keep in mind that your situation is unique. Everyone who comes into my office, while the general overall understanding that people need care and we need a social safety net to do that is the same, everyone's individual situation requires some specific tailored advice. What we are going to be talking about today is Medicaid long-term care. So everything I'm talking about is Medicaid long-term care. It is not Medicaid for adult children with disabilities, right? That's not the Medicaid that we're talking about. We're not talking about other kinds of Medicaid programs. We're specifically looking at Medicaid long-term care programs and what they cover. So all the qualifications that I'm giving you today are about Medicaid long-term care and not about any other kind of program. So only one of the 100 programs are we discussing. Okay, so it's a federal benefit program that's administered by the states. And so what that means is the federal government makes the rules and the state figures out how to implement those rules. It pays for the single largest share of long-term care. Most people in skilled nursing facilities receive some kind of Medicaid benefit, simply because the cost of skilled nursing facilities are so astronomically high. Even if they have a decent income and long-term care insurance, there might still be a gap, right? And then you have to meet to be eligible, you must meet the state and federal eligibility criteria. And again, this is for long-term care Medicaid. So what does Medicaid pay for? In the state of Texas, and I want to be very clear about this, because it is administered by the states, every state is different. So if you have a loved one who lives in Illinois and they're receiving a Medicaid benefit through their Medicaid long-term care program, and you think, oh, I want to move that person to Texas and we're just going to transfer their Medicaid benefits. It does not work that way. We do not transfer benefits. Whatever Medicaid program they had in Illinois may not actually be the same program that we have here in Texas. It is very, very important to understand that if you have seen one state's Medicaid program, you have seen one state's Medicaid program, and it does not transfer or translate in any way. Every state manages their Medicaid programs differently. So what it covers in Texas: skilled nursing, which is a nursing home, right? It's kind of what we all sort of think of when we think of, I guess the pejorative term would be old folks home, right? So that's a skilled nursing home. It can pay for some home health care or assisted living, though there are wait lists. And then once Medicaid, even if Medicaid is approved, you still have to find a provider, right? So Medicaid might cover home health care, or it might cover an assisted living facility. But if you cannot find a provider to come out and provide those home health care services, and you cannot find an assisted living facility who's going to accept that Medicaid waiver, then it doesn't really do you a whole lot of good, right? So these are all things that have to be set up ahead of time, that you need to know that you can get these providers. And there are wait lists, and the wait lists are about a year long in Harris County. And then it can also cover other supports and services as needed. For example, there are some funds available for small home modifications, right? So there might be some things there that you can get other funds for through the program. All right, so now let's talk about qualification, because qualification is the big key. This is what everyone wants to know about. How do we qualify? So somebody asking the questions, please explain skilled care as opposed to other types of care available. So that is a really good question. Skilled care is the need for unscheduled skilled medical care in a 24-hour period, generally speaking, right? So basically, skilled care is not just somebody who needs to be around to cook meals and get you from point A to point B, but skilled care is somebody who is a need for complex medication management, right? So if you're on many different kinds of medication and you need a nurse to come in and kind of help you make sure that you're taking them on time, that would be skilled care. Wound care, if there's something about your condition that causes skin lesions or something, you need wound care, that is skilled care, right? So skilled care is not very, it's a little vague. And so we kind of have to we rely on medical professionals to help us. I'm not a medical professional. I rely on medical professionals to help define when a patient needs skilled care. I rely on geriatric care managers to come in and do evaluations and tell me, yes, this person should meet the need for skilled care in a Medicaid context, or no, this person probably does not meet the need for skilled care. Because I'm not a medical professional, I have a very limited knowledge on exactly what's going to work, and I do rely on others to do that. But it is more than just, it's more than just the need for someone to be with them and make sure that they remain safe at home, right? That's not a skilled need. That would be custodial care. 100 days, the Medicare covers 100 days per event, and there are some timing issues. If you're home for a certain number of days and you go back into the hospital, then it'll depend on how long you were home as to whether or not that 100 days can start over again or not. And you don't have to go straight from the hospital to a rehabilitation facility, but they're within 30 days. That's on one of the slides. So those are the questions so far. Okay, so let's qualify for Medicaid. So a spousal situation, I'm focusing on spousal situations primarily because we have a lot more planning opportunities for spouses than we do for individuals. It still exists for individuals, but they're more limited. And spouses, in all honesty, what we're trying to do is make sure that the spouse at home has sufficient funds and sufficient resources available to continue living at home, right? So that's kind of where we're focusing our attention today. So husband and wife have $200,000 in savings. They have a home worth $300,000. Husband receives $2,800 in Social Security. Wife receives $1,800 in Social Security. Husband has a stroke and needs nursing care. It's going to cost $8,500 a month. That's pretty average. If the wife just tries to pay for it on her own, then it's going to eat everything up within about 3 years. So we want to avoid that, right? We want to make sure that the spouse at home is able to continue living. That's why we qualify for Medicaid. Medicaid qualification is a three-legged stool, and this is definitely an area where where people get tripped up. You have to meet the financial qualifications, you have to meet the medical and residential qualifications, and you have to have access to a program. I know many families who just apply for Medicaid because they know that their loved one needs help. So they just simply apply and then they get a denial. Well, they get a denial because they're not in some kind of program. And what I mean by that is they haven't been on the STAR Plus waiver interest list. So their name hasn't come up on this interest list to say that they are in a position where they are able to apply. And they haven't been in a Medicaid qualified bed for 30 days. So those are the two sort of criteria that you have to have. You have to have access to a program. A lot of people want to they think, oh, I'll just apply for Medicaid. And if they say yes, then I'll find a place. It doesn't work that way. We have to, it's the opposite actually. So the non-financial qualifications, you have to be over 65 years old, blind or disabled per the Social Security Administration, a U.S. citizen or qualified alien. And I get this question quite a bit in terms of what does it mean to be a qualified alien? That is a very complex determination. And it's based on how long the person has been here, what is their immigration status now. There are certain length requirements that they haven't, if they came to the US after a certain year, then they have to have worked for a certain number of years and built a certain number of quarters in order to be qualified. If they came prior to a certain year, then they don't have to. This is a question for your certified elder law attorney. If you are going in to do Medicaid planning for somebody who is a non-citizen, but might be a resident alien, then, or a permanent resident, then you can ask at that time whether or not they're going to meet qualifications. It's a very complex determination. You have to be a Texas resident and you have to meet medical necessity. So when we say Texas resident, you'd have to have an intent to be a Texas resident. So if you moved from Illinois yesterday to Texas today and you intend to have Texas as your home for the remainder of your life, then you are a Texas resident. Okay, we're going to look at these questions after the fact so that I can kind of keep going through this and then I'll answer the questions. We'll get back to them. So those are the non-financial qualifications. And then you have to have access to a program, meaning that you have to be in a Medicaid bed for 30 days or come up on the STAR Plus waiver interest list. You must meet all qualifying criteria by 12/01 on the first day of the month of application, meaning that you have to have met the medical necessity, which is the need for skilled care, right? You've met the financial criteria and you've met the access to the program by 12:01 a.m. on the first day of the month of application. So it's June 20th. If everything is set up so that you qualify on July 1st, if you file the application on July 15th, then they look back to July 1st to make sure that you were qualified on July 1st. Timing is literally everything in these applications. Okay, financial qualifications. This is where we get into the nitty-gritty. The income limit when one person is qualifying. So the income limit for a single individual is $2,740 a month. If both spouses are applying for Medicaid benefits at the same time, both spouses need nursing home benefits, both spouses meet medical necessity, and they are applying for Medicaid benefits at the same time, then the income limit is double, right? $5,484 a month. Countable asset limit is $2,000. Countable is the most important word in this phrase, right? There are countable and non-countable assets, and we'll get to that on the next slide. Countable asset limit of $2,000. That asset limit of $2,000 has not changed since 1989. Again, people with a higher pay grade than me get to make these decisions. It has never been raised for inflation. It has never been reviewed. I don't understand it. But that is the countable asset limit, $2,000. The countable asset limit for both spouses, if two spouses are applying, is $3,000. And here's where we get tricky. If we have one spouse applying and one spouse living at home, the applicant spouse can only have $2,000. The non-applicant spouse can have up to $148,620. That is a ceiling, not a floor. And we're going to talk about how we figure that out. That's part of these slides. And the spouse at home has a special needs allowance of $3,715.50. That's how much income the spouse at home can keep. And we're going to explain all of these as we go. Let's talk about countable versus non-countable assets. Countable assets generally is anything that you can liquidate within 20 days that is not in the non-countable list. Okay, that's it. So it's your cash, it's your, potentially it might be mineral rights. That's a very difficult calculation because it depends on the value of the actual mineral rights versus how much income it's kicking off. That is a calculation that has to be done to determine if those are going to be countable or not. Non-countable assets are going to be your homestead, right? Spouses have an unlimited homestead exemption. Individuals have a homestead exemption of up to $688,000. So if your home equity, if the equity in your home is worth less than $688,000 as a single individual, then it is a non-countable asset. You're entitled to one vehicle, irrevocable pre-need funeral contracts, some business property, some livestock, right? All of that has to be evaluated. It all has to be evaluated differently under different sets of rules, depending on what your circumstances are. But some of those might be non-countable assets that are not considered when we're talking about the Medicaid financial qualifications. So we're going to do a case study, right? So we can kind of like sort of walk you through the thought process of what goes into when we're making a plan, what it looks like. And I want to preface all of this by saying, I am presuming these are all just cash assets because it would be impossible to do a presentation that goes over all of the different kinds of assets and how they might be counted, not counted in any specific circumstance. So assume all of the assets here are cash. So we have a husband and wife with $200,000 in cash savings. We have a home worth $300,000. Husband receives $2,800 in Social Security. Wife receives $1,800 in Social Security. Okay. So first off, we need to understand income and assets are counted separately, right? So that slide that said the income amount that they're allowed is $2,742. And the asset limit is $2,000, right? So income and assets are counted separately. So husband and wife have $200,000 in cash savings. That's countable. Community property, separate property, I don't care. Premarital agreement, prenuptial agreement, marital agreement, Medicaid does not care. All assets for both spouses are counted together. If one spouse inherited $1 million from their family and they inherited it outright, it's their property and it's counted towards the other spouse. All assets are counted together if it is titled in either one of their names, okay? Either one of the spouses' names or both names, it's all counted as one big thing. So $200,000 in cash assets that are countable. I say that because I've had clients that were advised that they only had to give information for what was in the spouse needing only in the spouse's name that needs care. And that is not true. You have to give information for all of the assets that both spouses own. $200,000 in countable assets. Home's worth $300,000. It's non-countable. The husband receives $2,800 in Social Security. That is countable. And the wife receives $1,800 in Social Security. It is not countable because only the income of the person who needs benefits is counted. So let's keep this straight. Assets are all counted together. Income is counted separate. So a wife could be, or a spouse could have $10,000 in income. And if they are not applying, if they're not the ones applying for benefits, their income is theirs. It does not count against the other spouse. So income is treated separately, assets are treated together. Okay. So the husband and wife have $200,000 in countable cash assets. We don't have to worry about the $300,000 house. We don't have to worry about her Social Security. So we have $200,000 and $2,800 in gross income. Gross is also really important. It's not the amount that comes into your bank. It's the amount before Medicare is taken out, before taxes are taken out, before all of that. That's what matters. They don't account necessarily for certain taxes on certain things. So we always, if you're talking to an elder law attorney about this, if you're doing any kind of Medicaid planning, it is crucial that we know the gross amount and not the net that goes into your bank account. Okay. So what are we going to do? So $200,000 in cash, we split it. So the determination date, right? So we have to figure out when, because, you have to pay money. Money's coming out of your account all the time. So what's the date that we determine when we're going to split it? So the way it works is that on the first day of the month in which the spouse that needs benefits has been in an institution lasting longer than 30 days. So in our example, someone breaks a hip and goes into the hospital. They go straight from hospital to rehab. They go straight from rehab to a nursing facility. Oftentimes we can look back to that date when they first went into the hospital. And on the first day of that month, that is when we can determine what the assets are that we're splitting, okay? Timing is everything. This is complicated. I do not expect that any of you are going to be able to run out and take care of your own planning after this is done. But I want to give you a sense of what is that it is possible, that all hope is not lost, and that you don't have to be completely impoverished in order to get this done, right? I want you to know that there is light at the end of the tunnel when your loved one falls and we have to figure out how to pay for care. It's possible. That's why you go to a certified elder law attorney, is to help you navigate it. But this is sort of to counteract the bad information that is available on the interwebs. So they have $100. Our hypothetical couple has $100 in cash at 12:01 on the first day of the month that the husband went into the hospital with his stroke. So $100,000 is attributed to the husband, and $100,000 is attributed to the wife. That $100,000 she gets to keep. Done. That's hers. We can kind of get that off the board. And then the husband receives $2,800 in gross Social Security. So that $200,000 in savings, $100,000 is attributed to the wife. She gets to keep that. And then $100,000 is attributed to the husband. He's only entitled to keep up to $2,000. So we have to figure out what to do with $98,000. And then of course we have the income that we're going to deal with. So what can be done? So the husband has to we have to create a qualifying plan for the husband to deal with that $98,000. There are things that we might be able to do so that some of that can be used to be directed back to the spouse, right? So we create a plan to figure out what we can use that $98,000 for that is going to best benefit the spouse at home. And that $2,800 in Social Security is more than $2,742, right? It's only more by a little bit, but that's enough. That's enough to generally have disqualified him. So how do we manage that? So we're going to create a qualifying plan to reduce the husband's assets by $98,000. The husband is entitled, and then we're going to deal with the income. So a husband is entitled to $60 allowance. That actually got increased, I think, last month to $75 personal needs allowance. So that reduces the income to below the $2,742, right? So we're going to take 75 now instead of 60. And the spouse at home is entitled to a monthly income of $3,715.50. So we can divert some of the husband's income to the spouse, so the spouse gets up to that $3,715.50. So we don't have to spend all of the husband's income on the copayment to the nursing facility. The spouse at home does get to keep some of the income. And then the copayment to the nursing facility will be whatever is remaining after we take out for the personal needs allowance, the $75 for the personal needs allowance, and the and whatever we divert to the spouse at home. So the spouse at home does get to keep some of that income. So let's talk about myths that I've heard in my office. I can give up to $16,000 a year in anticipation of Medicaid. No, you cannot. That $16,000 that people talk about that you can give away, it's actually $17,000 now, and it's for gift tax purposes. It's an IRS rule. It's not a Medicaid rule. If you give $17,000 a year to somebody, it will be considered a gift for Medicaid purposes. And gifts given in anticipation of qualifying for Medicaid are penalized. It does not mean that the applicant is disqualified. It means that they are penalized. And what that penalty is a calculation that's made based on the amount of the gift and whatever the state's amount for the divisor is that year. There'll be a certain number of days that Medicaid is not going to cover the facility expenses. Okay, so it's a penalty period, not a disqualification. Okay, but you cannot just give things away. It's a 5-year look back period for gifts in anticipation of qualifying for Medicaid. I only have to report the assets in my sick spouse's name. No, you have to report all of them. There's no benefit to trying to be tricky. There's no benefit to trying to hide things, to try to get around the qualifications. Go to an attorney, let us do our jobs, let us show you what it's going to take to qualify and come up with a plan to help you. Because if you try to go around, if you try to be tricky and you are found out, then your loved one could be booted off the Medicaid rolls forever and never receive benefits. And there are criminal penalties that can come with anything that you might have done to try to undermine the system. There are rules in place that help us help people. We know what those rules are, and we can walk you through what you need to do to stay within those rules. But your attorney has to know all of the information. I don't care if it's savings bonds that you have in paper under your bed. This actually happened to me. Somebody did not disclose their savings bonds. So like, oh, how are they going to know? You know what? Every few months, there was this little deposit that happened in the bank account from the Treasury Department that was like some kind of interest. And it was, I don't know, pennies, right? But I had to figure out what that was. And when I asked, it was the interest on those bonds. Like there were certain things that were happening. And this is all in records. Like there's nothing we need to know. You have to be completely honest and upfront with your attorney so we can tell you exactly what needs to happen in order to get qualified and maintain qualification and allow your loved one to keep everyone out of trouble, honestly. A well spouse must completely impoverish themselves for their sick spouse to qualify. Absolutely not. That's kind of what we were talking about in the last one. There are rules that we can follow that can allow the spouse at home to maintain as much as possible so that they can live, right? Like no one wants to impoverish the spouse at home and have them on benefits as well. we are trying to take care of a loved one, and we're trying to make sure that the spouse at home has what they need to survive. If my spouse applies for Medicaid, the state will take my house. No, that is not the case. There is such a thing as Medicaid estate recovery, which is true in all states. Every state that has a Medicaid program has a Medicaid estate recovery program. In Texas, our Medicaid estate recovery program is actually very generous to the families. If there is a surviving spouse, there is no Medicaid estate recovery. It is a blanket exemption. That is not true in other states. In other states, the surviving spouse is entitled to live in the house until they die, but then the state puts a lien on the property. We don't have that here in Texas. In Texas, if you die on Medicaid and your spouse is still living and your spouse is in the house, then that is a blanket exemption to Medicaid estate recovery. There are several other exemptions that are worth looking at. Again, it's worth talking to your attorney about what that's going to look like. And there are ways to protect property from Medicaid estate recovery. And again, having that durable power of attorney makes it much easier to protect a house from Medicaid estate recovery. Without that durable power of attorney, sometimes it's a little bit harder. Okay, so planning for single people. The opportunities for planning are fewer, but that doesn't mean it's not there. And receiving help and guidance from an attorney might still be in your best interest or in the best interest of the individual. It's always going to depend on the type of assets and if there's any way to convert countable assets to non-countable assets. There are many circumstances in which an individual would otherwise qualify, but they have, $2,500 a month in Social Security, but then they also have a pension from a past job that puts them at $3,500 a month in income. Well, that's over our income limit. They don't have countable assets. That's necessarily a problem, but their income is too much. And so we can manage that by using something called a Miller Trust. Now, you may have heard of Miller Trust before. I had a client ask me about it yesterday. She wanted to know the difference between a Miller Trust and a living trust. Well, a Miller Trust is specifically used for Medicaid planning. It can only hold income. It cannot hold assets. It's only there to hold income that might be in excess of the qualifying income limit. It has to be managed in a very specific way because there are very, very specific rules that come with a Miller Trust. It is a great tool when we are in a situation where we need to make sure that somebody qualifies for benefits, but they just have a little bit too much in income. There is a big difference between $8,500 a month in nursing home expenses and $3,500 a month in income, right? We still have that gap that we have to cover. So that's when the Miller Trust comes into play, but it's only for income. It's income only. It cannot hold or protect assets of any kind. So common terms you might hear, Miller Trust, right? Spin down. Spin down takes many, many forms and really should be done in consult with your elder law attorney to make sure that we're preserving as much assets for a spouse as possible, or that we're doing it in such a way that is going to benefit the single person so that they have, so they can get as much benefit as they can prior to getting down below that $2,000. There's any number of things that we can do in terms of what we mean when we say spin down. Some of them are going to apply to some people and some of them are not going to apply to others. And so it's really, again, it's helpful to do this as part of a comprehensive overall planning program so that everything happens all at once. There's also Medicaid compliant annuities, but again, it should only be part of a comprehensive program. If you go online and try to piecemeal something together for qualification, you might succeed, but you might also get your loved one in a situation that makes it very difficult to qualify and difficult to unwind. And these rules that we have regarding Medicaid qualification are enormous and complicated, and there is a reason why only attorneys can charge for Medicaid planning services in Texas, because it's not, I don't know how anyone could do it on their own if they have anything at all that they're trying to manage. It's a difficult process. So these things you might hear of, there are things that you might have Googled yourself just to find out what it is. They are things that someone else may have used to great benefit. Wonderful. You should still contact somebody to make sure that it is cohesive with your overall plan, so that you make sure that you do what is in the best interest of yourself and your family. Gather your team. This is so crucial. Your financial advisor should be a part of this, because we may or may not be having to deal with things like retirement accounts. Retirement accounts are squirrely. If the retirement account is in required minimum distribution status, then we might be fine. It doesn't count as an asset. If it's not, then it does, or we might have to do something to it so that it doesn't, that we can turn it from a countable asset to a non-countable asset, right? So annuities, the kind of annuity you have matters. When you purchased it, what funds you used to purchase it. Sometimes it counts as an asset, sometimes it counts as income. All of these things we have to know about. So having your financial advisor involved becomes really important when working to get everything set up, so that they know what the plan is and they know what their part in it is. And so that they're not questioning, what are you doing, right? Because a lot of times what we have to do for Medicaid planning is not necessarily what a financial advisor would be advising you to do in order to make sure that your assets are as robust as they can be and that your return is as great as it can be. Because we have a different focus at this point. Right now, we're looking for qualification. We're not looking for growth. And so when we switch priorities and we switch how we're going to accomplish something, a lot of times we have to do that through doing things that your financial advisor is going to balk at. But they need to be involved in this. They need to be involved in part of this as we go. Your accountant, again, mostly for the same reasons as the financial advisor, your attorney, and your care manager. I know I've mentioned geriatric care managers before. I'm going to mention them again. They are such an integral part, especially if you have a borderline, if you're not sure if your loved one meets medical necessity, having a geriatric care manager who can come in and do an evaluation and give a report that then your elder law attorney can send to the Medicaid office, or can send to the nursing facility to put in your chart to send to the Medicaid office. Texas Health and Human Services, that can sometimes go a long way into helping achieve that medical necessity if we have this sort of third party, this third party report. And I'm going to say it again, every client situation is unique, because your financial situation is unique. Your homeownership situation is unique. Crisis planning can extend the life of your retirement to help pay for care, maintain spouse's quality of life. Pre-planning is definitely the way to go. If we're not in crisis yet, make an appointment, have the consultation with a certified elder law attorney, wherever you happen to be, just to get some advice, just to figure out what the next steps are and what needs to happen. It is going to save you in the long run if you do the pre-planning. But if we didn't get there, and that happens, it happens to a lot of people, they just didn't get around to doing it, or they didn't know what questions to ask. A lot of people don't even know elder law is a thing. We just don't have that kind of, that information is just not out there. And so now we're in crisis. Again, have a consultation with somebody. It's worth it to at least get some basic information about how this works and what your landmines are going to be. And keep in mind that only an attorney can charge a fee for Medicaid planning. There are a couple of companies out there that, you know, charge a fee and they say they will do your Medicaid application and they do your Medicaid planning, but they're not associated with an attorney. And I have several colleagues who have been involved in trying to unwind some of the damage that some of these places has caused. So be very wary of who you're working with. Make sure that you are working with an actual attorney and not just a company who might like farm out stuff to an attorney for review. You need to work with an attorney. All right, that is my presentation. I am going to leave this up there for just another moment. And then we'll get to some questions. So I have a question here. I'm looking at assisted living facility for my parents. Does this qualify for Medicaid assistance? Again, the STAR Plus waiver interest list is the only way to cover assisted living in Texas. But there are not a lot of assisted living facilities that accept it. So even if your parents do come up on the STAR Plus waiver interest list, you get them on the list and they come up on the list. If you haven't already arranged it with the assisted living facility and they haven't already agreed to accept it, then it might not do you any good. To my knowledge, there's only 3 or 4 places in the Houston area, assisted living places that accept STAR Plus waiver for assisted living. So that is something that you have to work out with the assisted living facility, as well as do the qualification for Medicaid. So it's a little bit more complicated when you're trying to get help for assisted living facilities. If you are looking for assisted living facilities, one of those partners that I was talking about are senior services locators. I'm a big fan. I use them all the time. They, as somebody who is knowledgeable about assisted living, independent living, all the different sort of personal care homes in the greater Houston area, they're going to know who's accepting the STAR Plus waiver and who isn't. They're going to know who has beds available and who isn't. So senior service locators are definitely a good resource to use. All right, I am going to stop sharing my screen and then get to some of these questions. Okay. Oh, this is a good question. Let's say I have a basic long-term care policy and $100,000 in savings. I own my home. Do I qualify for Medicaid, or would I need to use my savings in long-term care? Well, so as much as y'all are going to get super tired of this answer, it depends, right? So you have $100,000. That's over $2,000, which means that something's going to happen with that $100,000. As far as your long-term care plan, it depends on what kind of plan it is. If it's a traditional long-term care insurance policy that pays out $150 a day, let's say, that doesn't necessarily cover all of your Medicaid expenses. So if you have spent down your $100,000 and you otherwise qualify and your long-term care insurance policy is paying $150 a day, then you could potentially receive Medicaid benefits to pay the rest, right? Depending on what your other circumstances are. But you don't have to go through your long-term care policy in its entirety before you can qualify. It depends on the terms of the long-term care policy, how much they pay, what their limits are. So if you have a long-term care insurance policy, bring it into your meeting, to your consultation with your elder law attorney so that they can review it, so that they know what we're looking at and how it can be addressed. Does cash assets include IRAs? It depends. See, that is absolutely, that is one of those things. It depends. It depends on its status. Right now, we have an unwritten policy that says that if it's in required minimum distribution status and you're receiving income from it, then it counts as income and not as an asset. But It's an unwritten policy. We've been using it. If they stop that policy, they can do that. So it'll depend entirely at the moment that you're ready to apply. I can't answer that question. I wish I could. Individual accountable assets would include a home, because your example is for would individual accountable assets would include a home worth 127,000, because your example is for a married couple. So a home for an individual that's under 688,000 is still non-countable. So that's if the equity in the home is less than 688,000 for a single person, that is a non-countable asset. Is the care and room the same in a facility for both personal pay and Medicaid pay? To my knowledge, yes. There cannot be a difference. That would be discrimination. That would be discriminatory against the program. So my understanding is there should be no difference at all whatsoever in a facility accepting Medicaid pay versus private pay. And somebody asked for the slides from the first presentation, which I believe that there was an email that went out for all of that. Can my office provide information on where to search for certified elder law attorneys? The type that won't overcharge you for these types of services. You have to, this is complicated legal issues that require a lot of knowledge and a lot of time. Texas NALA, the National Academy of Elder Law Attorneys, is a great resource to find elder law attorneys in your area. You can put your zip code in and figure out exactly how long you want to, how far you want to drive. And then they'll give you elder law attorneys in your area. And some of them will have the designation CELA, that's certified elder law attorney, right? So if you have a CELA in your area, then that means that they have gone through the extra education and testing to become certified in elder law. But it's the National Academy of Elder Law Attorneys, NAELA.org. That is a great place to go to find elder law attorneys. And then talk to them.
I'm just going to interject really quickly. Some of you all are putting your questions in the chat. Please put them in the Q&A tab so we don't miss them. So if you did type we'll go to the Q&A, we'll go to the chat and look at the ones that were sent, prior to the presentation ending. But moving like from now until we close, just put it in Q&A, because I'm able to actually track them and clear them out. So it's much easier to make sure we don't miss your question.
Thank you. Why is there not a legal requirement to have an option to purchase a long-term care policy if you've been diagnosed with a long-term care illness? Someone's wanted to purchase a policy since they've been in their 50s, but they're restricted because of chronic illness. Contact your local representatives. I don't know whether there's not a law that requires them to be able to, because it's a business, right? Long-term care insurance, like insurance providers are able to insure what they want, how they want. Long-term care insurance is not particularly regulated. So as far as like the Affordable Care Act doesn't cover long-term care insurance. Some states are actually experimenting with requiring people to pay into a long-term care insurance policy. Washington just passed theirs. California is looking to pass one. So we're kind of in that experiment of the states area right now, with states trying to figure out ways to allow for people to get long-term care insurance, generally speaking. So it's one of those things where you just, if this is important to you, write your congressman, because there's not a law for it, then we have to do something about it. And I know that there's discussion amongst both state and federal level legislators that we need to do something about the long-term care crisis in our country. Everyone knows that. No one can agree on what the right decision is. And so we end up with this paralysis, like everything else, right? But if you want to see action on this, you have to get your local legislators involved. contact your congressman, state, federal, and let them know this is important to you and you want something addressed, right? I'm short 2 credits from 40 work credits, but I qualify for Social Security and Medicare through my husband. Would this qualify for me for Medicaid? Would this disqualify me from Medicaid? So your status regarding your work credits for Social Security have nothing to do with Medicaid qualification. So if you meet the other criteria, you're a Texas resident, US citizen, or qualified alien, and you meet the financial and medical requirements, then your Social Security status should have no effect on your Medicaid ability to qualify. CELA is short for Certified Elder Law Attorney, CELA. So when you see the CELA designation, CELA, then that is somebody who is a certified elder law attorney. How do VA benefits affect Medicaid? It depends on which VA benefits, right? I told you we're going to get really tired of hearing me say it depends. It's so true. It depends on which VA benefits you have, how you are receiving them, and what kind of Medicaid benefit you need. So if you are receiving VA benefits, this is something to talk to your elder law attorney about. And let them know when you go in for your consultation, hey, I'm also receiving VA benefits through this VA program. How is that going to affect my Medicaid benefits? I can tell you, if they are like pension benefits that you are receiving for aid and attendance because you have a low income and you meet the asset threshold. If you receive Medicaid in a skilled nursing facility, then those benefits are reduced to $90 a month, right? But that's just the one benefit under those very specific circumstances. So VA benefits can interact with Medicaid benefits. How it's going to interact is something that you have to talk to your attorney about. Is a ladybird deed considered for crisis planning when someone's getting in the later stage of dementia? Okay, let's talk about ladybird deeds. A ladybird deed is a very good tool to use if a person needs to pass a house to their family members, and it can be a way to protect it from Medicaid estate recovery, right? So you pass it outside of probate. Anything that does not pass in probate is not subject to Medicaid estate recovery. So we pass it using a ladybird deed outside of the reach of Medicaid estate recovery. A ladybird deed is absolutely doable in crisis planning when somebody has dementia, if there is a properly executed durable power of attorney with the right authority to execute a ladybird deed. That's it. I can't tell you how many people have sent me their durable powers of attorney asking me, hey, can we do a ladybird deed using this durable power of attorney? And honestly, the authority isn't there, right? So this is why I say, when you're doing these powers of attorney, it is important that you don't, like, if you do nothing else, if you don't go to an attorney for anything else, go to an elder law attorney to have your durable power of attorney drafted, because there are specific powers that we like to put in those documents to allow your agents to do things like ladybird deeds in a way that doesn't get you in trouble with title companies later on. Because while your agent might be able to sign that ladybird deed and everything might seem perfectly fine, when someone goes to sell the house later, the title company could say, oh no, this person didn't have authority. I don't see the authority in this document. I'm not insuring title. And so while it might have been while it might be generally a legal transfer, that does not mean that it's going to be easy later on. You need all of your ducks in a row. And the only way we can ensure that all of your ducks are in a row is to make sure that if an agent is signing that document, signing that deed, that agent has the power and authority to sign that deed. It is always best if the principal can sign it themselves. It is always going to be better if your loved one has lucid days, good days, then let's talk to them about it on a good day. And let's get this taken care of on a good day. A diagnosis of dementia does not automatically mean that a person is incapacitated or unable to make decisions for themselves. A diagnosis of dementia means that they're on a spectrum, right? It means that they might have good days still, they might have bad days. There might be times when they know exactly who they are, they know what they want to do, and they know that, and they're willing to talk to somebody about getting these things done. That is always going to be your best option. If that is no longer an option because they don't have good days anymore, then we have to review that power of attorney to see if the powers that are necessary to do the planning that we need have been included in that document. All right, I think that we've addressed everybody's questions. Does anybody have any more questions before I give you your time back for the rest of the day? And I thank everybody for coming. This last 3 sessions have been wonderful, great questions, a lot of people, but excuse me. And so
Angela, I think there's a question in the chat. I don't know if you
sure.
answered it. It says, let's see. It says, I'm looking at an assisted living facility for my parents. Does this qualify for Medicaid assistance? Did you answer that?
I did, yeah. So
Okay.
that's the one where the assisted living facility is the person that gets to make that decision, right? And it's going to depend on whether they accept the STAR Plus waiver. And then, you know, if your parents have been on the STAR Plus waiver and can then do that. Ooh, good question. If a home is transferred with a Ladybird deed, does the cost basis transfer with the recipient? It does. It does. So there's not a capital gains. That's the question. Ultimately, the answer to the question is there going to be a capital gains if you transfer via Ladybird deed for the people when they go, and when the family goes to sell it after a person passes, you get that cost adjustment, you get the basis adjustment, the basis increased at the death of the individual. So you do get the basis adjustment. If you have a loved one with dementia, how do we make an appointment on his lucid day? We never know when that is. That is true. If you find that there are times of days, if we're to a point where it's no longer like it's just random, then we might be past the point. If your loved one, you know that generally speaking, 10 o'clock in the morning, 11 o'clock in the morning is going to be their best time, but 2 o'clock in the afternoon is no good. Set the appointment at 10 o'clock in the morning, do a Zoom appointment or something so that you have it in their where they're comfortable. They don't have to move, because oftentimes when going from a facility or going from their home to the attorney's office can be exhausting. And if the more tired they get, the more likely they are to kind of lose the thread a little bit easier. So keep them comfortable, keep them at home, do a Zoom meeting or something of that nature if it's at all possible, so that they can talk to the attorney when they're having the best possible time. If like I said, if it's just random where, you know, one day out of 10, they might have a lucid moment, we might be past the time when we can really like do any documents. But that's something to, again, talk to your attorney about, to kind of see what their process might be for determining that. All right. All right. Do we have, if there's no other questions, I really enjoyed it. Thank you, Ariel, so much for inviting me. Thank you, AARP, for sponsoring me and letting me come and do this and talk. It's always fun. If anybody has any questions or wants to reach out, my contact information is available. And I am happy to talk to I'm happy to talk to anybody really about what we can do, how we can manage this.
Thank you, Angela. Thank you, everybody. We will be sending out the recording in the next few days, as well as the slides. So thank y'all so much.
Great.
Stay cool and
everybody.
stay
Bye-bye.
hydrated. It's
Right,
hot
stay
out there. Thank you.
Bye-bye.